All right, this evening I'd like to make a new video for you that describes Goddard versus Winchell. Give me a moment to pull up my slideshow and we'll begin. This is going to be a shorter lecture tonight. The value of this case as I see it is taking some time to think about how the results of this case might cohere with the results from Bridges versus Hawksworth and Hannah versus Peel. So if you haven't already read the case at this point, I'd like for you to put the video down and finish the reading and think about how this result coheres with what else you've read so far. The real value of this case and the assignment is going to be figuring out for yourself and trying to anticipate how all these legal rules cohere with one another. And if after reading the case you're still confused, then come back to the video and let me explain it for you. But you'll be depriving yourself of a great good if you just watch the lecture without having done the reading, of course. So the most important thing to learn from this case really involves just the limitations of finder's law. And so I don't anticipate that I'll be taking a very long time with this lecture, and I hope I haven't taxed you already with the length of the other two lectures for this week. This week will be a little bit atypical in that I have uploaded 3 different videos, and I don't mean to exasperate anyone, so this will be a shorter video, I think. But in the interest of time, let's get right to it, and we'll begin thinking about the timeline of this case. So the first thing of note is that in 1857, John Goddard, who is the defendant, I take it, in this appeal case, acquired title to a parcel of land in Iowa, and he owned it for many years until he decided to lease it to this guy, Ellickson, in 1890. Now, Ellickson has a very minimal role in this case. His neighbor, Hoagland, saw a meteor fall and then got Hoagland, and Hoagland basically watched as Ellickson basically watched as Hoagland dug up the meteor. And ultimately, Hoagland took possession of this meteor and sold it to this other person named Winchell for $105. But he overpaid a little bit for this because the court later found that the meteorite was worth only $101. Okay, so that's the basic structure of the case. Goddard leases this land to Ellickson. The land's used under the terms of the lease for grazing for his cattle. And then Hoagland watches a meteor fall into the ground. The meteor, we're told later in the case, is embedded 3 feet into the soil given the force of the impact. It's a huge meteor. And Hoagland digs up the meteor while Ellickson watches. He sells it to Winchell for $105. And then Goddard, the owner of the land, sues Winchell for replevin, meaning he wants the meteor back. He doesn't want the value of the meteor. He doesn't want $101. He wants the meteor back. And many times I've done searches trying to find a picture of this meteor to see if it's still in the family or something, and I haven't been able to find anything. And since I've been teaching this case for so long, and since it's a fixed part now of law school curriculum, it would be so interesting if we could get our hands on this meteor to see it, but I haven't been able to see it yet. That's the structure of the case. Again, you have basically the owner of a locus in quo claiming against a finder, somebody who's found something in some sense of the term finding. But what exactly that sense is will be a matter of dispute, won't it? So in accordance with our theme of the class, we're going to be thinking like lawyers, and we'll think again in terms of our IRAC method. We'll first think about what the issue is, then we'll think about the rule and the analysis that leads us to the rule, and then figure out what the conclusion of this case ultimately is. Now, the issue is basically what I've just told you, isn't it? The issue is whether a finder or an owner of a locus in quo has superior title to a meteor that was embedded in the soil. Who has better title to this meteor that was embedded in the soil? Well, each party has their own preferred rule that they'd like to see applied to the case. Goddard, the owner of the land or the owner of the locus in quo, wants the rule of the soil to apply. this rule of the soil has ancient origins. It basically says that whatever is affixed to the soil belongs to the owner of the soil. Meanwhile, Winchell's lawyer wants to argue that finder's law applies. Finder's law is what we've been studying so far in this course, and it says that a finder of lost property has superior title to the entire world except for the rightful owner. The case starts with Winchell's lawyer. And Winchell's lawyer argues basically twofold. He says that Goddard's preferred rule, the rule of the soil, it's outdated and it must be amended. The rule of the soil stated that the owner of property or realty owns everything affixed to or embedded in the soil. They say that this rule is the product of a feudal system, and that recently there are improvements that have been made to the rule. And so we ought to be progressively minded, according to Winchell's lawyer. We ought to abandon the rule. What are these progressive inroads that have been made to the ancient and hoary doctrine, as it's called in the text, right? Hoary with age. The accessions and the improvements that must be made, or that have been made historically, involve the idea that a tenant might affix certain things to the real estate, and the landlord is not thought to own that which is affixed to the real estate by the tenant, right? So that's supposed to be one kind of improvement. The other kind of improvement that's supposed to have been made is one regarding implements. So one who leases land is thought to also own the crops that grow on it. All right. And so I think what Winchell's lawyer wants us to think is, look at this ancient rule that's hoary with age. I mean, all of these improvements have been made on the rule. It's acknowledged to be outmoded. Let's go one step further and amend the rule to read like this. Only those things which become part of the soil and can benefit the land, which is really a sort of veiled way of saying only those things which can be adapted to the growing of crops, ought to be owned by the owner of the land. So anything in the land embedded in the soil that's adapted to the growing of crops or quote unquote benefits the land, as the lawyer euphemistically puts it, that should belong to the owner of the soil. But anything else is fair game. It's fair game, and it's much like the stuff that can't be found. Now, it's not exactly like the stuff that can be found, but you might think of lost property and natural resources alike as belonging to a common stock. Apples growing on the trees, found on the land without an owner, and a wallet that's lost in the street with no identification. Both of those things are in the common stock, and finder's law applies to that class of things. And so a finder like Hoagland should be able to come along and acquire good title to those kinds of chattels, those kind of movable properties. And since Hoagland is able to acquire good title, he should be able to convey it to Winchell by sale. And so Winchell, the lawyer wants us to think, has good title because of finder's law. So in summary, Winchell's lawyer argues, one, that his opponent's preferred rule must be amended, that it's antiquated and outmoded and hoary with age. Meanwhile, he argues that finder's law should be applied because natural resources are like lost property. Now, really, this strikes me as kind of a Hail Mary kind of argument, you know? It's not the kind of argument that one would make with a serious face, but, you know, lawyers are oftentimes paid by the hour. And so, assuming that Winchell is able to afford a $6,000 Meteor, or $101 in 1892, which would be about $6,000 today, he can probably pay a lawyer to make frivolous arguments in appellate court too. But maybe you didn't take this argument very seriously from Winchell's lawyer. I couldn't. I found it implausible. And the whole time I was frustrated while reading it. Maybe you were as well. Let's look and see what Goddard's lawyer says. Goddard's lawyer basically wants to say that a meteor becoming embedded in the soil is much like a pre-existing legal doctrine called the doctrine of accretion. To imagine what accretion is, you might imagine what would happen if you owned waterfront property, or put in legalese riparian title. Suppose you own this riparian title, and also suppose that you have neighbors who also own waterfront property. And then suppose that there's a storm that comes along and translocates, some of the silt or mud from your neighbor's property, and then it ends up on your property. Perhaps your shoreline is just a few inches longer than it was before the storm, something like that. And as a result of the storm, you now have property that's just a little bit bigger. It extends just a little bit further out into the water than it did before. And perhaps this is to the detriment of your neighbor, whose property now extends less into the water than it did before. Well, by the common law, this accretion, this improvement or addition to your land, is fair. It's fair because the natural forces acted in an unforeseeable way to make your property bigger. Sometimes you just get lucky, and sometimes you just get unlucky when it comes to natural events, right? And under this doctrine of accretion, those couple inches of shoreline that you have are now yours. Goddard's lawyers make the argument that a meteor falling onto someone's land and embedding itself into the soil is sufficiently like this, sufficiently like accretion. And they argue that the rule of the soil applies to this case. So a meteor falling into one's property is just like accretion, something already recognized by the common law. And so, because the meteor was by natural forces put into Goddard's land, it's fairly considered to be Goddard's property. It was embedded in his soil. Now, the court will basically and ultimately adopt Goddard's lawyers' argument almost without modification. They just add the idea that a meteor is not really lost property in any meaningful sense. It had no antecedent owner. Nobody owned a meteor before it fell onto Goddard's land. Whereas finder's law applies to those things only which have been owned previously. When we talk about finding something, we talk about finding something that has been lost. And the item's status as being lost presupposes a previous owner. Finder's law hence only applies to lost property, and a meteor is in no sense of the term lost property when it has no previous owner. And so finder's law cannot apply. For this reason, the conclusion of the case is that Goddard, the owner of the locus in quo, prevails over a finder, but arguably he doesn't do this in a way that is an exception to finder's law. Instead, this merely applies to a kind of resource that does not fall within the purview of finder's law. He did find, Hoagland did find the meteor in some sense of the term find. He discovered it, but he didn't find lost property. So he might be a finder, but he's not a finder in the sense that renders him under the purview of finder's law. And for this reason, the rule of the soil applies. And Goddard ultimately gets an award for the replevy for the return of the meteor that fell in his soil. That's really all I'd like to say in today's lecture. It's a shorter lecture. And again, the benefit for you is having thought a little bit about how this case could be squared with the results from Bridges versus Hawksworth and Hannah versus Peel. In the next reading that I'll assign for you and put up next week, you'll be given a basic summary of the law that basically tells you how the law has evolved in England and the US. So there's a difference between the way the United States handles cases of lost property, and there's a difference between the way England handles the law of lost property. They both have different conventions for dealing with these kinds of problems, and there's a nice, helpful outline that'll tell you everything we need to know about how to approach these questions in different jurisdictions. And then, having explained this outline to you, we'll begin doing a little bit of writing practice. And we'll practice writing like a lawyer, in which we write in IRAC format. We'll start our paragraphs with an issue, move on to a rule statement, conduct our legal analysis, and then try to draw a justified conclusion from what we've just said. So I think we have exciting times ahead of us. For now, I think that we've done a nice job of kind of explaining and looking through three important cases from the common law. And guess what? They'll come up again when we look at the outline for next week. So I hope you have a nice weekend. And I do hope you'll pop into the Friday section if you're so inclined to ask me questions about the reading.